Hello and welcome to our webinar today entitled New Risks and Opportunities Emanating from Distributed Workforces. There will be an interactive Q&A towards the end of the session. If you have any questions, please do drop them into the chat. We had a sudden accelerated shift to remote work and distributed workforces all across the globe. With this comes a series of compliance, payroll and tax-related challenges. Today, we'll be diving into some of those. We'll be taking you through some real-life examples of challenges that arise from distributed workforces in Europe, including cross-border workers and A1 certificates, and recommending ways to help mitigate these risks and optimize your policies. We are super excited to be joined by Alessio Rossi and Cord Vernunft from Andersen. Alessio is a specialist in tax law, tax consultant, and a managing partner at Andersen. His main areas of expertise are corporate tax law, specifically transfer pricing, tax structuring, tax disputes and investigations, and tax declarations. Cord is an attorney at law and partner at Andersen. Cord advises on all matters relating to employment law, including strategic and economic aspects involved. Cord is a highly experienced litigation lawyer who regularly appears before labour and civil courts. We also have Topia's very own Nishant Mittal, SVP of Topia Compass. Nishant is responsible for strategy and growth. Nishant is a published author with publications in machine learning and image processing in leading peer-reviewed journals. So with that, I'd like to hand over to our speakers.
Thank you, Holly. I think we will start this session with a poll question. Which of the following distributed worker issues keep you up at night? Is it A, posted workers directive? Is it B, managing cross-border workers? C, keeping up with country-by-country taxation laws? Is it D, understanding A1 certificate? Or is it E, just keeping up all of the above? It seems to be question number one, posted workers directive, that is attracting most attention, followed by managing cross-border workers and keeping up with country-by-country taxation laws. Just keeping up all of the above obviously attracts your interest too. So I'm quite positive that we will cover all issues addressed by this poll. Let's start with some definitions. We have integrated symbols into our slide deck. We start with the employer, top employee. The house, the castle-looking house is a business location. We will talk about place of residence, tax law. We have a shake hand symbol for social security law, and we make quite frequent use of the abbreviation DTT, which stands for Double Taxation Treaty. As indicated in the table of contents, we will have three cases that we will briefly introduce to you. Before we do so, we will enter into definitions. We have to understand what is a posting or a posted employee. This refers to an employee that is sent by his or her employer to another EU country to provide a service for a limited period. In this context, we differentiate between inbound and outbound cases. Obviously, being based in Germany, we talk outbound sending from Germany to a foreign country, and inbound the opposite. Posting implies that the employee lives in the country of assignment. In the outbound case, an employee with an unlimited tax liability is sent to, a domestic receiving company, or becomes active in Germany and has neither residence nor habitual abode in Germany. In our example, it is a Spanish employer that sends an employee to a German to a German workplace. Finally, and that's going to be the third case study that we'll present to you, we'll talk about cross-border workers. We understand why cross-border workers, employees who usually work in the border area of one state and return on a daily basis to their place of residence in the border area of the other state. We have chosen the example of the border area between Germany and Luxembourg, but could as well be Belgium, Netherlands, France, Switzerland, and you name it. But our example is going to be based on employees that commute on a daily basis from Germany to Luxembourg and back. So let's start with the first case study, which is, as indicated, the inbound case. I'll give you the background. A Spanish employer sends an employee to Germany for a period of 6 months. The employee works remotely from Germany and works solely for her Spanish employer, which is a relevant information. It's an exclusive activity for the Spanish employer. There is 2 frequent questions in this context: the regulations of which country apply and in which country taxes must be paid.
So in here, I take over. The first question is which part the employee will be in case of Social Security. And here we have an EU-wide direct regulation, which so that the law is in every country the same. Basically, it says that the employee is always part of that Social Security system he is working in. So the main point is where works the employee. And then under the European law, there are exemptions. And the most important exemption is the posting of an employee, which is regulated in Article 12 of the EU regulation, saying that you are allowed to post an employee 24 months to another European country, and that the employee may remains in the Social Security system of his home country. And the third exemption is always, which is also very important, is, but it's not here the case, another one, is when the employee works in several European countries, and this is regulated in Article 13. And by the EU regulation, there's also a big exemption, is that all the European states may agree on exemptions in an individual case. So in our case study here, the employee is working in Germany. That would normally lead to the fact that German regulation would apply, but here we have a posting of an employee, and the employee that doesn't is not longer than 24 months, so that the employee may remain in the Social Security system of Spain. And in this case, the employer has to apply in Spain for the so-called A1 certificate, which will then be issued, and the employee will remain in the Spanish social security system, and the social security contribution have to be paid in Spain. And now back to Alessio regarding taxation.
Thank you, Cord. As we just understood, for social security contributions, these must be paid in Spain, and we'll see if that applies for the tax side similarly. At this point in time, we talk first time about double taxation treaties. Just to give you a brief background, that's a treaty, that's a bilateral treaty between countries regulating which country has the right for taxation. So scenario one, is taxation taking place only in Spain due to the fact that the employee lives there? Or is it scenario two, taxation in Germany because the employees work there? Or do we have a scenario that leads to the fact that taxation happens in both countries? Let's start with the legal basis, and the basis Article 14, Double Taxation Treaty, Spain. If I say Spain, it means Double Taxation Treaty, Germany with Spain. So the principle is regulated in Article 14, paragraph 1. The state of residence has the right for taxation. This is obvious because the employee has his residence in Spain. Most likely, in many cases, family lives there, house is owned or apartment is rented. And the total social environment is in the country of origin. Obviously, there is no rule without exemption, and this exemption is stipulated in Article 14, the second part of the phrase. The state of residence has the right to tax the employee unless it is shifted to the state of activity. The state of activity in this example would be Germany, and the place of work for an employee is usually where the employee is physically present. Please note that the duration of the activity at this point is not important. The focus is on the physical presence where the contractual workforce is executed. In this case, in this specific case, there is a return exception. Article 14, paragraph 2 of the Double Taxation Treaty. The state of residence remains in the position of having the sole right of taxation if the conditions set out in Article 14, paragraph 2 are met cumulatively. There is the 183-day rule, which most of you may know. In our example, it's 6 months, so this exemption, this condition is met. The remuneration is paid by an employer in the country of residence. This is met because the employer is based in Spain, is paying out the remuneration. And last condition, the remuneration is not paid by a permanent establishment in the host state, in this example, the host state being Germany. So to answer the question, in this example, Spain has the sole right of taxation. Tax is payable in Spain. Wage tax is only to be paid in Spain. Paragraph 38 of the German Income Tax Code does not apply. Let's jump immediately to the second case. As explained at the beginning, we have focused on the inbound case, which was, in our example, a Spanish employer sending employees to Germany. Now we're talking about the other way around. It's the outbound case. In our example, a German employer sends an employee to Italy for an indefinite time. That's a difference to example number one. In this example, it is indefinite time. The employee who works remotely from Italy works solely, meaning exclusively, for the German employer. And the two questions are similar: the regulations of which country apply and in which country taxes must be paid.
Okay, this from a point of social security, this is a very easy case because here we do not have a posting within the meaning of the EU regulation because it's for an indefinite time. So the employee may not remain in the German social security system. He is part of the Italian social security system from the first day. So in this case, maybe here, because sometimes, of course, employees, they want to remain in their home, in the social security system of their home country, because they don't want to get like pensions at a later stage or from several countries, or there might be also problems regarding health insurance. So in this case, it might be for an employer advisable to, if it's not by demand posting for an indefinite time, just to post the employee for 24 months. But in this specific case here, the Italian social security system would apply. And back to Alessio regarding tax.
Thank you, Cord. We start from the same principle and the same legal basis. I'd like to point out, and maybe that has been a bit too quick in example number one, what is a situation that leads to a double taxation? In this case, as has been the case for in number one, the employee keeps his residence in his home country, and obviously being sent for 6 months, or in the Italy example, for an indefinite period of time, implies that the employee will have a residence in the state of work too. Other than the United States that focus their taxation rights on the citizenship, all European countries that focus on residence principle. So in these examples, the employee will run into a situation where he or she has two residences, one in the state of origin and one in the state where the work is executed, unless that's an exemption, maybe an exemption, that the employee gives up the residence in state of departure. But in our examples, there will be a remaining residence in home country, and in the Italy example, a new residence. Now, coming back to the residence principles, in these states, in these cases, two states would claim the right for taxation based on residence. Now, it would be Germany and Italy, and this conflicting situation is regulated by double taxation treaties, attributing the right for taxation to one or the other country, because it should be excluded that one individual is taxed on the same reason by two different countries. So starting from that principle, Article 15, and that's what I pointed out, starts with the resident state. So it is, in our example, Italy, because the employee moved to Italy for an indefinite time. Resident thus has moved to Italy. I think that's a reasonable assumption. Again, there is an exemption in the same article, which defers the right of taxation to the state of activity. So the place of work for an employee is usually where the employee is physically present, and the duration of the activity is thus not important. In our case, the activity, however, is executed in Italy, which means that the exception in our second example does not apply. And again, we have the return exception in Article 15, paragraph 2. The state of residence has the sole right of taxation if the conditions set out in Article 15.2 are met cumulatively. In this example, the employee moves to Italy for an indefinite period. You remember that in the Spanish example, the employee only moved for a period of, I think, 6 months. In this case, as it is for an indefinite period of time, the 183 days regulation is not fulfilled. So Article 15, paragraph 2 is not fulfilled either. The answer is the country that is attributed the right to execute taxes is Italy. And it will apply Article 24 of the Double Taxation Treaty, which regulates that where a person resident in the Italian Republic receives income which is taxable in the Federal Republic of Germany, the Italian Republic may, when determining the taxes on income referred to in Article 2, include that income on the basis of assessment for those taxes. Let's jump to our third study case. It's the cross-border workers case. The German employee commutes several times a week from Germany to Luxembourg for work purposes. The employee works partly in Luxembourg and partly remotely in Germany. which regulations of which country apply, and in which country taxes must be paid.
So from a social security point of view, here we have the case that the employee is working in two countries. So this is regulated in Article 13 of the EU regulations. And here it says that the regulations of that the member state of residence apply if the employee works a substantial part of his or her activity there. So it's more in the regular from, you have to determine whether he works more than 25% in his home country. So in our case study here, the German regulation only applies if the employee works more than 25% remotely in Germany. And if this is not the fact, the Luxembourgish law would apply. And here it's very important to determine, because here this depends where to pay the social security contributions. And in this case here in cross-border employees, this is not a case of where you have to apply for a A1 certificate, because here we do not have a case of posting of an employee. And back to Alessio.
So again, in our example, we have three questions. We have question number one: is taxation only executed in Germany because the employee lives there? Germany applying the residence principle. This is a question that makes a lot of sense, because based on the residence principle, one could think that Germany has the right to tax the employee. Or is taxation in Luxembourg, is taxation attributed to Luxembourg because the employee works there? As the employer has his registered seat there or place of management, there is a residence too. So the residence principle applying to Luxembourgish tax law too would imply that based on the execution of work in Luxembourg, one could think that taxation has to be performed in Luxembourg. Or scenario three, is the employee taxed in both countries? Again, we start with the Article 14. In this case, double taxation treaty, Luxembourg and Germany. The state of residence has the right of taxation. And as the German employee lives in Germany, state of residence is Germany, and the residence principle applies. The exception is, again, attributing the right of taxation to the state in which the work is carried out and has, and in this case, physical presence at work. The employee commutes to Luxembourg on a daily basis or frequently per week and works there, attributing the right of taxation to Luxembourg. So you see that we again have a situation of potential double taxation, if not the return exception applies. And we're back into Article 14, paragraph 2, stipulating the 183-day rule. In our example, at a commuting expense. Sorry, I can hear myself. Holly, there is a sound issue.
Can you try again?
I will try again.
Can you try going on mute for a second?
Okay. Yeah, I think problem is solved. Here I am back again. At a commuting expenditure of approximately 3 days a week, the 183 days are probably not exceeded. As condition B and C, in this case, we have no information. Normally, the AG, in this case, is the employer, is located in Luxembourg. Article 14, the exception does not apply. Leading us to the conclusion in this case. at a first step, both Germany and Luxembourg have the right of taxation. We'll talk about Article 22, paragraph 1. In case of a person resident in the Federal Republic of Germany, tax is determined as follows. Income from Luxembourg is excluded from the basis of assessment for German tax. Now, please note that this implies that work is executed in Luxembourg physically, meaning not only for the Luxembourg-based employee, but physically on Luxembourg territory. It's not intended that the employee is sent for business trips, attending exhibits or fairs, and visiting clients, but it is intended to stipulate the case where employees physically execute their work on Luxembourg territory. So for wage taxes, Article 38, paragraph 38 of the German Income Tax Code is not applicable. It is probably non-domestic employer. So income tax must be paid in Luxembourg. In this specific context, talking about the cross-border worker cases, we have been addressed with several questions from clients and individuals that have find themselves in a specific situation and were faced with implications of the COVID-19 pandemic, affecting, in this case, specifically commuters that were locked out of their commuting to Luxembourg because, as you may have heard or may be aware of, the borders have been closed in the first shutdown period that started in March and ended somewhere in May or June. So in the meantime, the employee was not allowed to cross border to execute work on Luxembourg territory. So at this point in time, the information that we have from both states is that this situation will not lead to a deferred view on how this individual is to be taxed. So the taxation rules that we just presented in our third case will still apply, even though due to the fact that borders have been closed and the employee could not cross borders to execute work, this could lead to a different assessment tax-wise. But as I said, states agreed that this should not be regarded as an exemption. That's the consultation agreement that the Grand Duchy of Luxembourg and Germany have concluded. Working days on which workers are working in the home office as a result of the measures to combat COVID-19 pandemic can be considered as working days spent in the contracting state, where the workers would have been working without the measures to combat the COVID-19 pandemic. It's the so-called fiction of facts. This does not apply to working days that would have been spent in the home office or in a third country independently of these measures. So that's what I was referring to. Business trips to visit clients or to visit and attend exhibitions would naturally not have taken place on Luxembourg territory. So those situations are not subject of the fiction of facts. The advice that is to be given to the employee is quite easy. Whoever wants to make use of this regulation requires a certificate from the employer stating the number of working days in which they have worked in home office as a result of COVID-19 pandemic. And the regulation is valid until December 31st of the year 2020, but given the current circumstances, there may be an extension of that rule. But so far, no borders are closed. Commuting is still permitted. And we'll see what happens if the consultation agreement will be extended over year end. So based on what we can tell you with regard to COVID-19 pandemic on the tax side, obviously there is a certain amount of criticism going on. We have no uniform rules. There is no thresholds regarding home office days. They're different at least. So there is proposed solutions that we have pointed out, taking home office working days close to the border out of the agreements for all employees who live within 50 kilometers from the border. It would also be possible to reduce home office threshold values to a uniform value of, for example, 15 days. Being asked how realistic such a change may be, on the scale of 1 to 10, the probability of a change is close to 0, according to other experts, because it would be intended a breach of the double taxation treaty, and those being bilateral treaties between two countries. Pragmatism cannot prevail, so we have to place formality over substance, and there's economic aspects that are have to be taken into account. In the specific case of Luxembourg, we talk about 450,000, 480,000 jobs in Luxembourg, including those that we consider cross-border workers. The number is quite impressive. It's 230,000 cross-border commuters that make about 40 to 45% of all jobs in Luxembourg. So there is a high economic relevance in this context. And I think at this point, I can pass the word to Claude, who will guide you through the A1 certificate specifics.
So again, some words regarding the A1 certificate. This is how a German A1 certificate would look like. What you all know, if you're in Germany, that at least in Germany, the A1 certificate can only for employees applied in an electronic form. You do that via your personal software and personal management software. And Nishan also will elaborate later a little bit about how the software of Topia can help you to manage the A1 certificate. And regarding the A1 certificate, it's also, you have to know that also if you have a very short business trip, that also in these cases, you need a A1 certificate, and that there are a lot of European countries who start to check at airports if also business travelers carry their A1 certificate with them. Nowadays it's in a written form, but in the future, I guess from 2021, it also will be in an electronic form that the employee has to carry with himself. So Alessi, could you change to the next slide? Yes, and now I just want to say for what's the goal of the A1 certificate. Because when you travel across the European Union and they have different social security systems, and for the employee, it's very important that he is always part of just one social security system, and also from a perspective of an employer, because then you just have to pay social security contribution to one system. And the A1 certificate is a certificate showing in which social security system the employee is insured, and then he doesn't get any problems when working as a posted employee in another country. And the A1 certificate has to be applied in every individual cases, but in cases where an employee travels a lot, you also can have A1 certificate that lasts for a longer time, and for also for different countries if an employee travels several European countries. And it always states the beginning and the end of the assignment or posting. Yeah, next. And also, due to the COVID-19 pandemic, there's a problem. What happens if there are like errors regarding the posting, that, for example, the employee went home or and after a certain time when goes back to this country. So, and also for cross-border employees, what do you have to keep in mind? So if the posting abroad is interrupted just for a very short period, there's nothing you have to keep in mind. So here, if it's just for 2 months, an interruption, you do not have to apply according to the German National Association of Health Insurance. You don't have to apply for a new A1 certificate. The old one will remain valid. And then the next question is what happens to cross-border employees. Also here, there are no changes with regard to the applicable Social Security law. And also, if the employee is working for a longer time, for example, in his home country, which could also be seen if there's, so if for example, an Luxembourg employee normally working in Germany now stays in Luxembourg, or no, and this cannot be seen as a posting of an employee. So an A1 certificate is not needed. And furthermore, regarding employees who have normally workplaces in different European countries, and now that it's also they just work from one. Also in this case, will be, according to our German national social security system, no changes regarding the regulations which are, or agreements between states what were made before the pandemic. So the employee may remain in the social security system in which he was before the pandemic. And just one here also regarding this slide, if caused by the pandemic, the posting of the employee takes longer than the original time which you applied the A1 certificate for. In this case, you would have to apply for a new one. And this is, I guess, next one, Alessio. So I think it is again a question which is done by Nishan.
Okay, so this is Nishant, and I will be asking you the poll question. Next year, that is in 2021, do you expect your employees or your clients' employees, if that's relevant, that they will be working from home all the time, 50% of the time, rarely working from home, or they will be back in the office full time? Also, Alicia, in the meantime, if you can stop sharing your screen, then I can share my screen. All right, and I think that we have our responses. So Holly, are you able to read out the responses?
Of course. So the most prominent response is 86% expect their employees to be back in the office 50% of the time. We have 7% saying working from home all of the time, and 7% saying rarely from home, and there was no responses to say they expect employees to be back in the office full time.
Yeah, and that aligns with at least what we hear and see in the marketplace today, that it is unlikely that we will have all the employees who are going to be coming back to work full time, or even a meaningful amount of time, at least in 2021, and likely even beyond that. I think some of the models for how we expect people to work are likely going to be disrupted and changed for a really, really long time to come, with employees expecting a much more flexible model of work, a much more fluid way of working, which obviously makes planning for a lot of the folks who are on this call a lot more difficult. But if that becomes the way that the world is moving to, then obviously we need to adjust to that new world, a world in which the fundamental paradigm that we expect most of our employees to be at work will likely be true for many years to come, but rather that population that we were expecting not to be in the office, that population that used to be a much smaller part, will now become likely a much larger part. And I think that is what is giving a lot of HR departments, global mobility departments, and other departments a lot of pause to understand, what does it really mean when you have employees who will be spending time in a lot of different jurisdictions. And as you already heard from both Alessio and Cord, there is no one implication of employees spending time across different borders. There are a number of different implications. We heard a lot of numbers in there, the 183 days, 25% of time, 3 days in a week. So there are a number of different thresholds that now need to be kept in mind, which basically necessitates the understanding of where people are traveling and how much time they're spending in different places and the activities that they may be performing, because it has an implication on the individual income tax. It may have implications in terms of the withholding that may need to be done, the permanent establishment that a legal entity or business unit may create, statutory requirements that may exist in different countries, such as the filing of Appendix 4 in the UK. And obviously there are a number of compliance things that need to be done as folks are crossing these borders, in terms of the A1 certificates, the post-work
Nishant is frozen. Bear with me 1 second.
So Holly, can you hear me?
Yeah, we have you back now.
Okay. So how do you manage the complexity that comes with this kind of cross-border travel? And the response to that basically has to be in technology. There is no way to be able to manage hundreds, possibly thousands or tens of thousands of people who are moving across borders, and to be able to manage and to be able to even have visibility into the kinds of risks that it may create. Which is why a technology that allows you to be able to understand the footprint of where people are spending time is very, very critical. This basically will be only accomplished if you have data sources that allow you to understand where people have either traveled historically or where people will be traveling in the future. So we see a lot of clients starting to adopt technology that can look into travel bookings, into expense systems, things like VPN or IP logs, and also be able to deploy certain applications that can, in a private but in a secure way, help understand which tax jurisdiction is an employee spending time. Being able to combine that with different rules, different policies for different countries These may be statutory rules of the countries or maybe business policies that you as an organization want to apply. And then at the end of the day, if you are going to have hundreds or thousands of folks who are going to be out in the field, then how do you make sure that each individual employee does not have to bother about each and everything that may be happening as they travel, but only be alerted, only have to report on, and only have to comply with the things that are relevant. I think being able to get to a point of end-to-end automation across that is what is going to allow companies to be able to manage these complex cross-border risks that arise, especially in this new environment. There are multiple ways where you as an organization can start to capture this information. As I mentioned, travel bookings, expenses, these are great data sources that you can leverage. These may already exist within your enterprise systems. Also, when you think about forward-looking compliance on a pre-trip basis, knowing when somebody has booked a flight, when somebody has booked a hotel, or some sort of another indication that allows us to know where people will be traveling, then can allow the opportunity to do an A1 assessment or post-worker assessment, an immigration assessment, so that the right filings can then be made with the right authorities. Once you have this information, you should be able to understand what your global footprint looks like. You may have an employee who is regularly based out of Netherlands, but is now suddenly in Bali because they are working from home and the family just decided that during the COVID era, they're just going to go to Indonesia and work from there. These kinds of things can have very far-reaching implications for you as an organization, as well as for the employee. And that's why having that visibility is critical. Once you have that visibility as to where people are traveling and how much time they're spending in different places, you can start to have alerting. So in the case of Alicia and Cord, when they were talking about the 183 days in Luxembourg, how do you actually keep track of that? How do you enable employees to easily be able to keep track of that? In this case, once we understand where people have been, you can now actually have a cumulative year-to-date count and understand how many days has an individual spent time in that particular jurisdiction, so that to the extent that they need to leave that jurisdiction in time so that they don't cross that threshold, that they're able to actually do that. In the event that there does need to be allocation between different jurisdictions based on the various rules that were already talked about earlier today, then that allocation of income can be done in different places if you knew where your employees are. And having the ability for employees to be able to manage that information, so that to the extent that a certain day was not a work day, but it was either a personal day or a conference day, or they were traveling to another jurisdiction, which may now be excluded from Luxembourg in the example or the case study that we talked about, then that management of that information becomes easy and can be done in technology versus having to rely on people's memory and to be able to do this in either Excel files or over email, so that we can streamline this process for thousands or hundreds of people, as may be the case. Once you have that kind of information, you can also start to monitor permanent establishment risk that may be getting created in different places. Permanent establishment obviously is a very complicated concept, but a big piece of it does involve who is traveling, where they're traveling, how much time they're spending on behalf of a legal entity, and what activity they would be performing in a particular jurisdiction. And so being able to monitor that once you understand where your people have traveled is critical, because permanent establishment then has a number of downstream implications, such as local laws and requirements, transfer pricing, etc. And then lastly, if you do have individuals who will be traveling from one jurisdiction to another, being proactive in helping that individual understand that they may have responsibility for either getting an A1 certificate or doing a post-worker registration becomes critical. And it is only with technology that you can enable your employees to be empowered with that information as to when do they need to go take some action. And so being able to send them that alert saying, hey, you booked travel, and so you may have that A1 certificate requirement that you can now file with the German authorities, and being able to take them through a process where most of the work is being done by some sort of an automated system, by pulling information from your HRIS system versus having the employees to go and fill in all that information manually, I think will allow for much higher levels of compliance because you are making the life of the employee easier. At the end of the day, this is a corporate responsibility. Making sure that A1 certificate is on file is a responsibility for the company. And so you do want to make sure that you have a process in place that makes it easy for the employees to be able to comply with it and for the organization to have good visibility into it. So a lot of the world is becoming more and more complicated. There is a lot to think about and a lot to deal with, especially in this new environment. But the good news is that there is a lot of technology that is available out there that can be leveraged to help manage these processes and these risks, together with the advice that your tax advisors such as Andersen are able to provide. So with that, I am going to pause because I see that we only have 10 minutes left and would like to open it up to questions. You should have the ability to type in your questions and send it to us, and we will then do our best to answer as many of the questions as we receive. Also, if you have questions for either Alessio, Cord, or myself after this presentation, please don't hesitate to reach out to us, either of us or all of us. Our email addresses are listed here. I see some questions coming in. Please do send in your questions while I pull it up. I'll be reading the questions and then one of us will respond to it. So the question. Okay, so one of the questions that we just received is that will we be sending the recording of this presentation? The answer is yes, we will be sending out a link to the recording by email to all participants who have registered after this presentation. Okay, I see more questions coming in. Okay, so one of the questions that maybe Alessio, Cord, if you guys want to take this, what have you seen companies do with their internal policies when it comes to managing their employees who are working across borders?
Thank you, Nishant. Let me start, maybe Cord can chime in. First of all, we strongly advise our clients to have guidelines and have a written guidelines for the employees in case they are subject to be sent to another country. Obviously, that's something that's an issue on data collection side. So our advice is to have something in written and then address the facts that the individual taxation needs to be taken care of the employee itself. We're most of the time advising the employer. So the advice is stipulate written guidelines and include the fact that the taxation issues of the employee that is leaving for another country for work purposes should be taken care of by the individual itself. So yeah, that's basically the main advice that we can give in that context.
The A1 certificate and application for that is, of course, that within the European Union, the countries started to check whether the employees carry the A1 certificate with them, also when they are on just a business trip. Companies becoming aware of that, they monitor whether the employees apply, or they try that every employees have to report when they go on a business trip abroad, and so that the A1 certificate can be applied in advance.
Okay, thank you.
Yeah, this indeed, if I may add, Nishan, is also important for taxation purposes. You always have to keep track of where your employees are. So that's something that I would suggest, including guidelines, that you have a data collection facility to have your employees inform you as an employer about their movements.
Great, thank you, Alicia, for adding that. And I think that piggybacks very nicely on another question that we received, which is sort of a continuation of what you just said, which is technology and the application that I was just showing, does that provide support for Social Security and taxes? And the answer to that question is yes. And I'm happy to answer any more detailed question separately, Gabriela, if you would like. Another question that I think is in the same spirit, Alicia and Cord, if you want to take it, is there a general trend by companies to allow people to work from home in a different country to their employing country? What are you seeing in the marketplace? And I'm happy to chime in here as well.
Well, first of all, I think, Cord, if you want to start, because working on a remote base requires an agreement between the employer and the employee. So that's a subject of labor law that in the first step, Cord, correct me if I'm wrong, both parties need to agree and provide for the right to execute home or telework.
It's under German law, it's not necessary, but it's advisable to have an agreement regarding remote work, because there are a lot of questions that under German employment law have to be regulated, like health and safety in the home office, or who is liable if there is a damage, etc., etc. But there's also, I think, a trend in Germany and I think across the European Union that there are more and more employees not only working at home, but also working from abroad, who like work and travel in a new way, so that they don't work in the country they are traveling to. They keep on working for their company in the home country. They work remotely, and there are several implications to the labor law and social security law, and also regarding taxation. So in this case, there are a lot of questions that have to be answered, and also during the COVID-19 pandemic, because here also because I'm based here in Berlin, and we have quite a lot of people coming across Europe to Berlin, work in the new economy and startup business. And during the pandemic, a lot of them went home, back to their home countries, and they work remotely from home. And we will see if this is a trend that will, also if after the pandemic is over, will succeed, so that the traditional understanding that an employee has to be in the office to work in a proper way. And I think there are a lot of employees who learned that, employers who learned that also that an employee can perform very good his work from home or from abroad. And so here in Berlin, for example, the prices, the rent prices for offices, they drop because a lot of employers, they want to stay with the home office so that they don't need so much space.
Yeah, I think, Alicia, we're seeing the same here in the US as well. Yeah, the only thing I'd add to that is, what I'm seeing is that there are some employers who are getting ahead of this and actually putting in policies saying, well, if you are going to work from a place that we were not expecting you to work from, which is different from what your HR system or payroll system reflects, then you need to let us know and you need to get approval before you do that. So companies who are doing that are able to at least have some visibility. Obviously, compliance with that is not always 100%, but at least having a policy tells the employees that they should be discussing this with their employer before just picking up bags and going to Bali to work. So So yeah, I think those employers are certainly ahead, and I think if there are employers who have not put such policies in place, then I certainly would suggest talking to your tax advisors and your legal advisors to put something in place like that. Another question that came in was around A1 certification application process, and where does the data actually come from? In some of the screenshots that I was showing, does it come from the company's HR system? And what if the data is not in the system? So the screenshots that I was showing you, yes, I mean, at least in our technology, we plug into various internal systems, such as your HR system, your ERP system, and to the extent the information that is required and is already available in those systems will be automatically populated so that the employees don't have to go in and put that information in every time. Obviously, there will be some pieces of information which are not going to be available in the HR system or the ERP system. They may be very specific to the trip or the travels that are coming up, or other pieces of information that may just not live there in your existing systems, in which case there is an entire workflow which notifies the employees to complete that information that is not available in the in-house systems, so that all the data fields can be collected in an online system and then be fed into an A1 process. And the system that we have built does cover all the European countries to which the A1 certification process applies. Okay, another question coming in here, maybe this will be the last one because we are a few minutes over. Do remote employees or commuters qualify for posted worker directive requirements? Cord, Alicia, did you want to take that?
Sure.
As lawyers always say, it depends. So if it's like if an employee is posted to, for example, from Germany to Spain, and he works there remotely, this is of course an example of the EU directive. And also if the employee goes voluntarily to, for example, for 2 months to Spain during the pandemic and he works from home, he also needs a A1 certificate so that he remains in the social security system in Germany. But if you employ directly an employee in another country, for example, as a German employer, and I know, okay, for example, I get very good technical experts in programming in Romania, for example, and I employ them directly in Romania. This is not a case of posting an employee. And so here, the employee is employed in Romania, and from the day one, he is part of the Romanian social security system.
If we have a minute more time, I'd just wrap up from a tax perspective. Taxation right would at first glance follow what Cord said. So first of all, it's the legal basis that counts, but then tax auditors or tax officials in the assessment would have a closer look at it, because it also depends to which benefit the work is executed. So if it's a remote worker in another country working for the benefit of the employer, let's say, stick to our example, Luxembourg. If it's a Luxembourg-based employer and the work is performed remotely to the benefit of the Luxembourg employer, I would not see that being qualified for tax purposes as a posted worker. But the situation may change once the employee starts working for the benefit of the employer on German ground. There is a certain risk, and that's something that I would advise everybody to have to monitor that situation. There is a risk of having a permanent establishment. The permanent establishment itself is not tax risky from a point of view of tax evasion or tax fraud. It's just it becomes risky when it's an undetected permanent establishment. What happens is stick to our example, the employee starts working for the benefit of the Luxembourg-based employer on German territory, closing contracts, doing business development activities, marketing activities. So forming something that is considered of a permanent establishment and economic benefit to the employer on German territory. That could be a situation where the tax authorities would have a closer look at it. It's wage tax is one side, but the income tax in this case, maybe corporate income tax or the business tax implications should be monitored. So to sum it up, a clear regulation between employee and employer makes a lot of sense because it clarifies the questions upfront. In case such questions or such regulations are missed out, we advise you to just draft something to have a clean sheets.
Brilliant. Thank you to everyone for joining us today, and a special thank you to our wonderful speakers, Alessio, Cord and Nishant. If you do have any questions, please do reach out to us, and any questions we didn't have time for today, we will follow up with afterwards via email. So thanks again for joining, and we will look forward to seeing you again soon.